Welcome to the Professional Texas Real Estate Exam Preparation course. This content is for informational and educational purposes only and does not constitute legal or professional advice. This course is an unofficial, independently produced study guide and is not affiliated with, endorsed by, or connected to the Texas Real Estate Commission, TREC, or Pearson VUE. All trademarks belong to their respective owners. Always consult with qualified legal or real estate professionals regarding specific licensing requirements or legal matters. This module serves as your definitive guide to understanding the licensing requirements and the structure of the Texas Real Estate Commission examination. We are going to demystify the path toward becoming a licensed salesperson by focusing on the specific mechanics of the Texas real estate market. This course is designed for those who appreciate precision, logic, and a structured approach to learning complex legal and regulatory frameworks. By stripping away extraneous noise, we allow the core concepts of licensure to emerge clearly, ensuring you possess the technical knowledge required to pass the TREC test on your first attempt. To begin, you must understand the 180-hour qualifying education requirement, which serves as the foundational academic hurdle. This mandate covers core real estate principles, law of agency, law of contracts, promulgated contract forms, and real estate finance. The application process is managed through the TREC portal, where you will submit evidence of your education alongside proof of your identity. You should anticipate a mandatory background check and fingerprinting, which are non-negotiable steps in the certification process that verify your suitability for licensure. The exam itself is administered by Pearson VUE, and it is crucial to understand the logistical environment you will face on test day. The examination is divided into two distinct sections: the national portion and the state-specific portion, both of which require a passing score of at least 70%. You are allocated a specific amount of time to complete these multiple-choice sections, which demand not only a mastery of facts, but also the ability to apply those facts under time conditions. We will focus our efforts on strategies that leverage active recall to ensure you are comfortable moving through these questions with efficiency and confidence. Throughout this course, we will consistently bridge the gap between abstract legislative requirements and the practical, daily operations of a license holder. You will learn to navigate the complexities of property law, fiduciary responsibilities toward clients, and the specific disclosure requirements mandated by Texas law. Instead of relying on rote memorization, I encourage you to view these regulations as the underlying architecture of your future practice. Understanding the reasons behind a law often makes it easier to retain the details of the law itself. We will move through these topics logically, building upon each concept as we progress toward mastery of the material. This orientation is your roadmap for success, and by strictly adhering to the methodology presented, you will find yourself well prepared for the examination ahead. I look forward to guiding you through this process with clarity and focus. I will see you in the next module. Welcome to this section where we will explore the foundational legal framework governing our profession in Texas. This chapter is essential because it provides the bedrock upon which all your future brokerage activities will be built. If you want to succeed in the real estate business, you need to understand the rules governing it. By mastering the Texas Real Estate License Act, you are positioning yourself to pass your certification exam on the first try. You will learn everything required about the regulatory environment that protects your clients and licenses alike. Choosing this course proves you are serious about becoming a professional practitioner who knows exactly how to navigate state requirements. The Texas Real Estate License Act, commonly referred to as TREC, is codified under Title VII of the Texas Occupations Code as Chapter 1101. Its primary existence serves a singular, focused objective the protection of the public from dishonest or incompetent practitioners. While we often think of regulations as bureaucratic hurdles, they actually serve to maintain the reputation of the industry and keep barriers high enough to ensure professional quality. When you operate under TREC, you're not just following rules. You're upholding a standard that keeps the real estate market functioning predictably. It defines who is authorized to facilitate transactions and how they must conduct themselves to remain in good standing. This legislation is why a license holder must operate with transparency, as the state assumes that parties lacking this knowledge cannot adequately protect their financial interests. Central to this regulatory apparatus is the Texas Real Estate Commission, which consists of 9 members appointed by the governor. Out of these 9, 6 must be licensed brokers who have been active for at least 5 years, while the remaining 3 members represent the general public and have no financial interest in real estate. This deliberate composition ensures that the commission is not merely an echo chamber for industry insiders, but a balanced body weighing individual practice against consumer protection. Their authority is substantial, as the commission holds the exclusive power to issue, suspend, or revoke licenses based on violations of the Act. They serve as the enforcement arm that translates legislative intent into actual oversight. By sitting on this commission, these members effectively police the industry to keep bad actors from causing systemic damage to the reputation of Texas brokers. Distinguishing between those who require a license and those who do not is a frequent point of confusion, yet the legal criteria are surprisingly clear. Generally, any person who acts on behalf of another for compensation or the promise of compensation in a real estate transaction must hold a license. However, the Act provides specific carve-outs for individuals who are not engaging in brokerage as their primary business or capacity. For example, property owners managing their own assets do not require a license because they are acting in their own interest rather than representing a client. Similarly, licensed attorneys in Texas are exempt when performing tasks incidental to their legal practice, provided they do not attempt to hold themselves out as real estate brokers. These exemptions exist because the law recognizes that certain professional roles or personal ownership situations do not involve the same level of fiduciary risk to the general public. Financial accountability is reinforced through the Real Estate Recovery Trust Account, which acts as a safety net for those harmed by a bad-acting license holder. This fund is sustained by contributions from new and renewing licensees, ensuring that money is available to satisfy judgment claims that a broker might not be able to pay. When a court determines that a consumer has suffered monetary loss due to a violation of the Act, they may seek compensation from this account. However, there are strict caps on these payments to preserve the solvency of the fund. Specifically, the maximum payout per single transaction is limited to $50,000. Furthermore, the lifetime aggregate limit for claims against a single license holder is restricted to $100,000, which forces brokers to prioritize ethical conduct to prevent these claims from ever reaching these thresholds. Maintaining an active license is not a passive task, but rather a continuous commitment to ongoing education and adherence to brokerage protocols. Each licensee must monitor their own compliance, ensuring they do not stray into the practice of brokerage without proper authorization, which is a criminal offense in the state of Texas. Unlicensed practice is taken seriously because the law treats brokerage as a specialized service where the client's money and legal rights are at stake. A person attempting to collect a commission without a license would have no legal standing to sue for that compensation in court, which is a powerful deterrent. By following these rules, you protect your ability to earn a living and ensure that your contractual agreements remain enforceable. When you understand these mechanisms, you gain the confidence to handle complex client interactions without fear of regulatory reprimand. See you in the next lecture. Welcome to the chapter on Commission Authority, where we will examine the regulatory framework that governs your professional license in Texas. We will analyze the specific powers granted to TREC and how these rules translate into your daily practice. The Texas Real Estate Commission, or TREC, functions as the primary regulatory body overseeing the real estate industry in the state. Its rulemaking authority is derived directly from the Texas Real Estate License Act, which necessitates a structured approach to public protection. When the Commission drafts rules, it is essentially providing the necessary detail for the statutes passed by the Texas legislature. These administrative rules carry the same weight as law, meaning that noncompliance can lead to severe disciplinary consequences. Understanding this relationship is foundational because it dictates how you interact with the public, your clients, and the Commission itself. As a licensee, you're not merely encouraged to follow these guidelines. You are explicitly required to incorporate them into your professional operations. Failure to grasp these nuances often leads to avoidable administrative action that could jeopardize your career. The Commission possesses considerable investigative powers, including the authority to subpoena witnesses and documents to ensure compliance. When a complaint is filed, the process begins with an investigation, which is prioritized based on the potential risk posed to the public. If a complaint is deemed valid, TREC has the power to impose administrative penalties or even move to revoke a license. Crucially, there's a 4-year statute of limitations for filing complaints against a license holder. This time frame is significant because it protects you from indefinite liability, though it also underscores the importance of keeping meticulous transaction records. The investigative path is rarely arbitrary, as the Commission follows specific protocols to ensure that due process is upheld throughout the inquiry. You should view these rules not as obstacles, but as the boundaries of a professional environment designed to ensure market integrity. One of the more unique aspects of Texas real estate regulation is the specific role assigned to the Broker-Lawyer Committee. This committee is responsible for drafting and revising the promulgated contract forms that you will use in almost every transaction. By utilizing these standardized documents, the industry minimizes the risk of the unauthorized practice of law while ensuring consistency across the state. Furthermore, the Education Standards Advisory Committee plays an equally vital role in maintaining high professional standards. This body provides recommendations regarding the curriculum for salesperson apprentice education, known as SAE, and the ongoing requirements for continuing education. These educational mandates ensure that licensees remain informed about shifts in the market, legal updates, and evolving ethical expectations. When a dispute reaches the stage of formal disciplinary action, the process moves to the State Office of Administrative Hearings, commonly referred to as SOH. This is a critical stage where the license holder has the right to present a formal defense against the allegations brought by the Commission. An administrative law judge oversees these proceedings to ensure that the hearing remains impartial and adheres to strict legal standards. You are entitled to be represented by counsel, present evidence, and cross-examine witnesses involved in the case. The outcome of a SOH hearing can range from complete dismissal of the complaint to the assessment of fines, suspension, or permanent license revocation. Recognizing the gravity of this process is an essential part of your professional development because it reinforces the necessity of strict regulatory adherence. See you in the next lecture. Welcome to this chapter, where we will examine the nuances of real estate licensing in Texas and the various professional designations recognized by the Commission. You will gain a clear understanding of the specific eligibility requirements, the broker-salesperson relationship, and the regulatory obligations that govern your practice. To obtain any real estate license in Texas, a person must meet the fundamental eligibility criteria established by the Texas Real Estate Commission. An applicant must be at least 18 years of age, a citizen of the United States or a lawfully admitted alien, and a legal resident of Texas. Beyond these basic demographic markers, the Commission places a significant emphasis on moral character, which they often refer to as integrity. This assessment is not a suggestion, but a strict requirement, as TREC evaluates whether an applicant possesses the honesty, trustworthiness, and integrity necessary to represent the public interest. If you cannot demonstrate these qualities, the Commission has the authority to deny your application regardless of your examination scores or educational background. Failing to meet these standards of character remains the most common obstacle for initial applicants, so treat your background evaluation with the same seriousness as your study materials. The categories of licensure create a clear hierarchy that defines how a licensee interacts with the public and other professionals. A sales agent is the most common entry point and must always act under the sponsorship of a licensed broker, meaning they cannot operate independently or manage their own trust accounts. To transition from a sales agent to a broker, the law requires 4 years of active experience as a salesperson within the preceding 5-year period. Furthermore, the applicant must accumulate 3,600 points under a specific point-based system that quantifies various real estate transactions and experience types. Once an individual secures their broker's license, they become responsible for the professional acts of every agent they sponsor. This relationship functions similarly to a principal-agent arrangement, where the broker is the guarantor of legal compliance for their entire team. Maintaining a license is a dynamic legal obligation that involves strict adherence to renewal timelines and specific display requirements. Licensees must complete mandatory continuing education to renew their status, and failing to provide this proof before expiration triggers late renewal penalties. If a licensee decides to take a break from the industry, they may move to inactive status, which suspends their authority to practice but preserves the underlying license under the sponsorship of a broker. When actively practicing, you must prominently display your license in your place of business, ensuring that clients have clear evidence of your current status. The law also mandates that you provide the information about brokerage services form to clients at the first substantive communication, while the consumer protection notice must be posted in a conspicuous location in your office and on your digital platform. These requirements ensure that the public remains informed about how agents operate, the nature of representation, and the existence of the recovery trust account. Understanding these regulatory frameworks is essential for navigating the complexities of the Texas real estate market as a licensed professional. I will see you in the following segment. Welcome back. This chapter focuses on the canons of professional ethics and conduct, which define the moral and professional obligations governing Texas real estate practitioners according to the Texas Administrative Code. In this chapter, we will dissect the core pillars of professional behavior as mandated by the Texas Real Estate Commission to ensure you are fully prepared for the state exam. We will cover the specific canons of fidelity, integrity, and competence, while also examining the mandatory consumer protection notice and the strict legal prohibitions against discriminatory practices in housing. By mastering these standards, you are not just learning to pass a test, but you are acquiring the essential framework for a compliant and successful real estate career in Texas. This curriculum is designed to simplify complex regulatory language into clear, actionable principles that you can apply immediately in your practice. You will emerge from this course with a rock-solid understanding of your ethical responsibilities, which remains the single most effective way to protect your license and your reputation. The foundation of practitioner conduct in Texas is rooted in the 5 canons established in the Texas Administrative Code. The canon of fidelity is perhaps the most significant, as it mandates that a license holder must represent the interests of their client above all others, including their own interests. This is the fiduciary core of your role, requiring you to remain loyal and protect your client without compromising the duty of honesty owed to other parties in a transaction. When you act as an agent, your personal gain, whether financial or otherwise, must never supersede the specific objectives of the person you represent. It is not enough to simply be transactional. You must act with a clarity of purpose that keeps the client's goals at the forefront of every negotiation and advisory conversation. Failing to adhere to this standard is not merely a professional breach, but a direct violation of the foundational rules set by the Commission. Flowing directly from this is the canon of integrity, which dictates that a license holder must exercise prudence and caution to avoid misrepresentation through commission or omission. Integrity in this context is the active pursuit of truth, requiring you to be scrupulous and meticulous in your disclosures. If you are aware of a significant defect in a property or a material fact that could influence a buyer's decision, failing to disclose that information is an ethical failure. This canon specifically requires that you be aware of market conditions and legal developments that might affect your client. You're not expected to be an attorney, but you are expected to know the limits of your expertise and to direct clients to the appropriate experts when a situation falls outside your professional purview. Misrepresentation is a high-stakes violation that often results in severe disciplinary action, including the potential revocation of your license. The third primary canon is competence, which holds the license holder to a standard of excellence in professional knowledge and skill. Competence implies that you must stay informed about current market trends, property values, and the various legal requirements that govern real estate in Texas. You cannot be considered competent if you are stagnant. You must commit to ongoing education and a deep understanding of the intricacies of the local and state landscape. This canon is also an active defense against liability, as a competent agent is far less likely to commit errors that lead to lawsuits or administrative complaints. When you verify information, consult with experts, and refuse to guess at legal implications, you're actively practicing the competency standard required by the state. It is a commitment to the public trust that ensures the industry maintains a high baseline of quality for all consumers. Beyond these canons, the duty of consumer information serves as a critical bridge between the profession and the public. Texas law requires the mandatory use of the Consumer Protection Notice, which must be displayed in a readily accessible location in your place of business. This notice informs consumers about how to file a complaint with the Commission and how to access the Real Estate Recovery Trust account. It is not optional. It is a regulatory requirement that reinforces transparency. Furthermore, you must ensure that your advertising practices comply with strict standards regarding identity and accuracy. All promotional materials, including social media posts and digital advertisements, must clearly show your broker's name or your registered DBA to ensure that consumers are never misled regarding who is actually responsible for the service being offered. Ambiguity in advertising is a common trigger for investigation, so precision in identifying your brokerage is paramount to staying within the lines of the law. Discriminatory practices represent a bright-line rule that transcends simple professional ethics and enters the realm of the Fair Housing Act and state-level prohibitions. The Commission has adopted a zero-tolerance stance on any behavior that violates the rights of consumers based on protected classes such as race, color, religion, sex, national origin, familial status, or disability. This is not about personal preference or individual business choices. It is about the enforcement of human rights within the context of housing. Any attempt to steer clients, limit housing options based on identity, or express discriminatory preferences in your marketing materials is a grave violation of law. You must understand that housing discrimination is not always overt or intentional. It can manifest in subtle choices about where you suggest a client look for a home, which is why strict adherence to universal, non-discriminatory service policies is the only acceptable approach for a modern, ethical license holder. Distinguishing between ethics and law is a common point of confusion for new agents, yet the difference is vital for your practice. While the law provides the absolute minimum standards for behavior, representing the boundary between what is legal and what will result in sanctions, ethics represent the higher standard of conduct expected of a professional. If you focus only on the law, you will spend your career looking for loopholes or trying to determine exactly how close you can get to a violation without crossing it. If you focus on ethics, you build your career on a reputation of trust, which is far more durable and ultimately more profitable. Ethics effectively raise the bar, ensuring that your behavior remains unimpeachable even in situations where the law might be ambiguous or silent. Understanding this distinction allows you to operate from a position of confidence, knowing that your decisions are guided by industry-wide principles rather than individual convenience. See you in the next lecture. Welcome back. In this chapter, we will examine the professional procedures and the specific mechanics behind how the Texas Real Estate Commission handles complaints against license holders. The TREC complaint process is structured to prioritize public protection while ensuring due process for the license holder. When a complaint is filed, the Commission first determines if it has jurisdiction over the specific matter and whether the allegations, if proven true, would constitute a violation of the Texas Real Estate License Act or TREC rules. If the complaint moves forward, an investigation is conducted to gather evidence, which may include interviewing witnesses and reviewing relevant documentation like contracts or communication logs. If the evidence supports a violation, the Commission may move to initiate disciplinary action, which can range from administrative penalties and reprimands to the suspension or revocation of a license. Conversely, complaints are dismissed if they lack sufficient evidence, fall outside the Commission's authority, or involve matters that are purely civil disputes between private parties. Understanding this life cycle is critical because it highlights that every action a licensee takes represents a potential evidentiary trail. Licensees must maintain rigorous record-keeping practices not just to satisfy curiosity, but to demonstrate compliance should an investigation ever be initiated. The goal is to ensure that you are always acting within your scope of authority and documented responsibilities. A significant area of focus during both investigations and daily practice is the unauthorized practice of law among real estate professionals. While you are responsible for facilitating a transaction using TREC promulgated forms, you must never move into the territory of drafting complex legal clauses or providing legal advice. Your role is to fill in the blanks correctly, not to create new, specialized legal language to appease a client's unique request. If a client insists on adding a provision that is not covered by standard form or a promulgated addendum, your only proper course of action is to direct them to an attorney. Attempting to draft custom contracts or offering legal opinions on property rights exposes you to significant liability and potential license revocation. You must remember that your expertise lies in market analysis, property representation, and contract facilitation according to strict standards. When you overstep into legal advice, you're not acting as a consumer advocate, but as a liability magnet for your client and yourself. Always maintain the boundary between real estate brokerage and the practice of law to verify that your professional integrity remains intact. The handling of earnest money is another area where procedures are strictly enforced, as it involves the temporary safekeeping of a client's significant financial assets. TREC rules mandate that earnest money must be deposited into the designated escrow account by the close of the second business day after the effective date of the contract. This timeline is firm and does not allow for managerial discretion or delays for minor logistical inconveniences. You must ensure that your brokerage has clear internal controls to verify that these funds are managed accurately and transparently. Furthermore, the handling of compensation requires careful attention to the prohibition against splitting fees with unlicensed persons. While it is legal and common for brokers to split commissions with other licensed brokers, providing any form of compensation, gift, or referral fee to an unlicensed individual is a violation of the law. This prohibition is designed to prevent unlicensed interference in real estate transactions and ensures that those performing brokerage activities are properly vetted and regulated. Sticking to these strict financial and fee-related guidelines protects your license from severe disciplinary measures. Finally, the maintenance of a branch office and the role of the designated broker are structural requirements that every entity must respect to remain in good standing. If a firm operates in multiple locations, Any branch office must be properly registered, and the business entity itself must have a designated broker who holds a high level of responsibility for the supervision of all sponsored agents. This specific oversight ensures that there is always a layer of professional accountability attached to the brokerage's activities. A designated broker is not just a title, but a functional role that requires staying apprised of current statutes and ensuring that all activities under the brokerage banner are compliant. If the designated broker is unable to perform their duties, or if the firm fails to meet physical or operational registration requirements, the entire organization risks losing its authority to practice. These rules exist to guarantee that there is no gap in responsibility within a business operation. By verifying your branch is correctly established and your supervision structure is sound, you demonstrate a commitment to the administrative realities of Texas real estate law. See you in the next session. Welcome back to our journey through the complexities of the Texas real estate landscape. In this chapter, we will focus on the mandatory disclosures and postings required by Texas law to ensure transparency and consumer protection. The information about brokerage services, commonly known as the IABS, is perhaps the most critical document you will encounter regarding client communication. You are required to provide this form at the first substantive communication with a party regarding a specific real property. Substantive dialogue involves more than just pleasantries and includes any substantive discussion relating to a specific property. Failing to provide this notice in the prescribed format as established by the Texas Real Estate Commission can lead to severe disciplinary actions. The form must be presented in at least a 10-point font and must be kept in its original, unaltered state. It is not an agreement that creates agency. Rather, it is purely an informational document designed to explain agency roles. Ensure you are familiar with the current version on the TREC website, as using outdated forms is a preventable compliance error. By delivering this consistently, you establish a professional standard that protects both your license and the consumer. When representing a seller, the seller's disclosure notice under Texas Property Code 5.008 is a mandatory requirement for most residential transactions. This notice is a statutory requirement that forces the seller to disclose the known condition of the property to the potential buyer. Many agents mistakenly believe they can fill this out for their client, but this task is the sole responsibility of the seller. There are specific exemptions to this rule, such as transfers pursuant to a court order, foreclosures, or the sale of a brand new home that has never been occupied. If you're dealing with a property that is sold by an executor of an estate or a trustee in bankruptcy, the disclosure requirement might also be waived. However, if the seller resides in the home and it is a resale transaction, the document must be provided before the contract is executed. If a buyer does not receive the notice before signing, they may have the right to terminate the contract for any reason. Environmental disclosures present a different set of challenges, particularly concerning lead-based paint and general hazardous materials. Federal law dictates that any residential property built before 1978 requires a lead-based paint disclosure. As a professional, your duty is to ensure the buyer receives this disclosure and the associated pamphlet prior to becoming obligated under a purchase contract. Beyond lead, you must also be aware of disclosures for other defects, such as a history of mold or environmental hazards located on the property. While you are not expected to be an environmental engineer, you must disclose all known material facts that could impact a buyer's decision. If a client mentions a hidden issue, such as a past fire or a known structural defect, you cannot hide this information behind a veil of confidentiality. Transparency here is not just an ethical imperative, but a legal requirement to avoid claims of misrepresentation or fraud. Texas law maintains unique definitions regarding stigmatized properties, which often causes confusion for new licensees. You are not required to disclose that a death occurred on a property due to natural causes, suicide, or an accident unrelated to the condition of the property. In fact, you are strictly prohibited by law from disclosing that a previous occupant had or was suspected of having HIV or AIDS. While you do not have to volunteer information about these factors, if a buyer specifically asks, you must answer truthfully if you have knowledge. Regarding registered sex offenders, Texas law does not impose a duty to disclose, nor does it prohibit it, but it is generally recommended to refer buyers to the public sex offender registry. This allows the consumer to perform their own due diligence without the agent assuming liability for providing potentially inaccurate information. These rules require a delicate balance between professional conduct and the specific privacy rights afforded under the law. Finally, we must address the specific disclosures concerning tax districts and coastal properties. If a property is located within a municipal utility district or another statutory tax district, the seller must provide a notice to the buyer regarding the associated taxes and potential annexation. Failure to provide this notice in a timely fashion can lead to the buyer having an absolute right to terminate the contract prior to closing. For coastal properties, you must disclose the reality of water level fluctuations and the potential for the property to be located seaward of the vegetation line. These disclosures are part of the broader effort to ensure that buyers understand the long-term financial and physical risks associated with their purchase. By mastering these specific details, you position yourself as a competent advocate who views real estate through the lens of legal compliance and consumer safety. I will see you in the next lecture. Welcome back. We are now turning our attention to the specific legal frameworks that define how property is held and protected within the borders of Texas. Texas law treats real estate ownership through a unique lens, particularly when it comes to the homestead and the way married couples categorize their assets. Understanding these distinctions is not merely an academic exercise, as these principles dictate the validity of listing agreements, the enforceability of liens, and the fundamental rights of property owners. We will dissect the constitutional protections afforded to the homestead and contrast them with the rigorous requirements of community property laws that apply to marital assets. By the end of this session, you will be able to distinguish between protected homestead interests and the complexities of separate versus community property. This knowledge is essential for navigating the transactional requirements that you will encounter daily in your practice. The Texas homestead is perhaps the most powerful protection a homeowner has under state law, serving as a shield against forced sale by general creditors. This protection is embedded in the Texas Constitution, acknowledging that a family's primary residence should be insulated from the volatility of financial misfortune. However, this is not an absolute immunity, as the law provides specific, constitutionally defined exceptions where a creditor may legally force a sale. These exceptions typically include non-payment of property taxes, purchase money mortgages, and properly executed home improvement or mechanics liens that follow strict constitutional procedures. It is vital to understand that a homestead cannot be waived by a simple contract if the property truly acts as the primary residence of the owner. Therefore, whenever you list a property, your due diligence must include verifying the homestead status to ensure that all necessary parties provide consent for any future encumbrance or sale. The geographic extent of this homestead protection is strictly defined by the Texas Constitution, and it varies based on whether the parcel is characterized as urban or rural. An urban homestead consists of a lot or contiguous lots totaling no more than 10 acres, which must be served by police protection, fire protection, and at least 3 municipal services like electricity or water. In contrast, a rural homestead allows for a much larger footprint, permitting up to 200 acres for a family and 100 acres for a single adult. These classifications are not merely about acreage. They represent the state's historical commitment to supporting its residents' ability to sustain themselves, whether in a city center or on agricultural land. Misidentifying the classification or the acreage limits can lead to significant legal complications, especially during title transfers or equity cash-out refinances. As a licensee, You're not responsible for performing a land survey, but you must be able to recognize when a property might trigger these specific constitutional protections. Moving into the realm of marital property, Texas operates under a community property regime, a system where the law presumes that all property acquired during marriage is owned equally by both spouses. This presumption is strong and requires clear, convincing evidence to overcome when asserting that an asset should be considered separate property. Separate property consists of assets acquired before the marriage or assets acquired during the marriage through a gift, devise, or descent. If one spouse owned a house before saying their vows, that house remains their separate property unless they intentionally move to commingle it with community assets. The complexity often arises with the passive income generated by these separate holdings, such as rental income or dividends produced by a separate asset. Under Texas law, that income is treated as community property, which is a common pitfall that often surprises investors and new licensees alike. The most practical implication of these laws for a real estate agent is the requirement for joinder when dealing with a homestead, regardless of whose name is actually on the title. If a property serves as the homestead for a married couple, both spouses must sign off on any sale or mortgage. This rule serves to prevent one spouse from effectively depriving the other of their home without an intentional, documented agreement. Even if the deed lists only the husband as the owner, if that land is their established homestead, the wife holds a possessory interest that necessitates her signature on the closing documents. If you fail to ensure that both spouses have signed the listing agreement or the contract, you risk rendering the entire transaction voidable. Always verify the marital status of your clients, as it is your duty to ensure the legal chain of title remains intact and enforceable for the buyer. I will see you in the next lecture. Welcome back to our journey through the legal landscape of Texas real estate. In this lesson, we will dissect the concepts of liens, deeds, and the various interests that define how property ownership is structured and protected. To understand the legal foundation of real estate, we must start with the concept of an encumbrance, which is any claim, right, or interest held by someone other than the owner that limits the fee simple title. Liens are the most common form of encumbrance, acting as security interests in real property to protect a debt. We categorize these into voluntary liens, such as a mortgage where a borrower pledges their property for a loan, and involuntary liens, which are imposed by law without the owner's explicit consent. Common involuntary liens in Texas include property tax liens, which take top priority over almost all other interests, and judgment liens resulting from legal proceedings. A specific concern for Texas practitioners is the mechanics and material man's lien, often called an M&M lien, which protects those who provide labor or materials for property improvements. Because these liens can arise even if a general contractor fails to pay a subcontractor, they pose a significant threat to a clear title. Texas law is quite strict regarding the priority of these interests, usually following the principle of first in time, first in right, though property taxes consistently jump to the front of the line regardless of filing dates. Understanding the chain of these filings is essential because an undetected lien creates an immediate defect in the title that must be resolved before a property can be transferred. While the lien represents a debt against the property, the deed represents the physical act of transferring ownership from the grantor to the grantee. For a deed to be legally valid under Texas law, it must meet several non-negotiable requirements, beginning with the identification of the parties and the inclusion of valid consideration. You must ensure the deed contains a precise legal description of the property, which is far more specific and permanent than a simple street address. The document must be signed by the grantor and delivered to the grantee, with the subsequent acceptance by the grantee completing the transfer of title. We classify deeds based on the scope of the protection provided to the new owner, with the general warranty deed offering the highest level of assurance. This deed guarantees that the grantor holds clear title and warrants against all defects occurring throughout the property's entire history. Contrast this with the special warranty deed, where the grantor only warrants against defects that occurred specifically during their period of ownership. Finally, we have the quitclaim deed, which contains no warranties at all, effectively passing whatever interest the grantor might have, if any, without guaranteeing that the title is clear. Recording a deed in the county clerk's office serves an essential purpose in the Texas legal system by providing constructive notice to the public. Constructive notice is a legal fiction that presumes everyone has the opportunity to know about the status of a title because it is a matter of public record. When a deed, mortgage, or other interest is properly recorded, it establishes the priority of that interest against subsequent buyers or creditors. If you fail to record an interest, you risk losing your claim to a subsequent bona fide purchaser who might acquire the property without knowledge of your unrecorded right. This is why title companies are so rigorous about checking the grantee-grantor index for every potential legal entanglement before a closing occurs. Beyond voluntary and involuntary claims, we also encounter physical encumbrances on the land, most notably easements and encroachments. An easement appurtenant involves two separate tracts of land where one party, the dominant estate, has the right to use the land of another, the servient estate. An easement in gross, by contrast, is a personal interest, such as a utility easement that benefits a company rather than a piece of neighboring land. An encroachment occurs when a structure or improvement, like a fence or a shed, crosses the property line and extends into a neighbor's property, creating a potential boundary dispute that could jeopardize future marketability. See you in our next session. Welcome back. In this chapter, we will master the precise language of property location by examining legal descriptions, boundary laws, and the essential water rights governing Texas land. When we approach the legal identification of land, we must first distinguish between the three primary methods used in Texas. The metes and bound system is the most common in the state, relying on a point of beginning followed by a series of directions, distances, and landmarks that close back at the start. You will frequently encounter references to varus in historical Texas documents, a unit of measurement equal to 33 1/3 inches that dates back to Spanish colonial rule. In contrast, the lot and block system, also known as the recorded plat method, is typically reserved for residential subdivisions where a developer has filed a master survey with the county. When looking at a plat, you are viewing the visual representation of these boundaries as recorded in the county clerk's records, whereas a survey is the actual measurement and physical drawing performed by a professional surveyor regarding a specific parcel of land. The rectangular survey system, or government survey system, uses a grid of meridians and baselines to form townships of 6-mile squares, which are further divided into 36 sections of 1 square mile each. Understanding these distinct methodologies is crucial because a deficient legal description can render a contract unenforceable, creating significant professional liability for you as an agent. Mastery here requires that you always verify the description against the most recent survey or deed record. Beyond the lines on a map, Texas law dictates how landowners interact with the water positioned on or beneath their property. We characterize water rights based on the nature of the water source, specifically distinguishing between riparian and littoral rights. Riparian rights pertain to land that borders flowing water, such as a river or a stream, granting the owner reasonable use of that water provided it does not impede the rights of downstream users. Littoral rights, however, focus on static or standing bodies of water like lakes, bays, or oceans, where the owner typically holds title to the land up to the mean high water mark. Groundwater in Texas presents a unique scenario governed by the rule of capture, which effectively allows a landowner to pump as much water as they can beneficially use from beneath their land, regardless of how this pumping might affect a neighbor's water supply. You must also understand how land boundaries change due to natural forces over time. Accretion is the gradual process of adding soil to land through the action of water, while alluvion refers to the actual accumulation of that soil or deposit. Conversely, avulsion is the sudden and violent removal of soil, such as a flash flood changing the course of a river, which generally does not change the legal property boundary, unlike the slow process of erosion. To avoid fundamental errors in your practice, you must be able to classify the physical objects associated with the property. The term land refers to the physical surface, the subsurface to the center of the earth, and the airspace above. Real estate expands this definition to include land plus all human-made improvements, such as houses, fences, or sidewalks attached to it. Real property constitutes the broadest term, as it includes the physical land and real estate, but also incorporates the bundle of legal rights that accompany ownership, such as the right of possession, enjoyment, and alienation. When we discuss items within these categories, we must identify if they are fixtures. A fixture is personal property that has been attached to the land or improvements in such a manner that it becomes part of the real estate. To determine if an item is a fixture, we apply tests such as the method of attachment, the adaptability of the item to the property, the intent of the party who installed it, and the existence of any agreement between the parties. If an item is permanently affixed, it transfers with the property in a sale unless the parties have specifically excluded it in the contract. Recognizing these distinctions prevents disputes during closing, ensuring that the property being conveyed matches the expectations of both the buyer and the seller. Please proceed to the next session. Welcome to this chapter on land use controls and zoning, where we will demystify how public and private entities regulate the use of real property in Texas. Mastering these concepts is essential to ensuring you pass your exam and provide accurate guidance to future clients regarding what they can and cannot do with their land. Public control refers to the government's inherent power to regulate land use for the protection of public health, safety, and welfare, a concept broadly known as police power. Zoning ordinances act as the primary instrument here, dividing land into specific districts such as residential, commercial, or industrial, each with its own set of permitted uses. Building codes represent another layer of this protection, establishing the minimum standards for materials and methods of construction to ensure structural safety. When a property has been used in a certain way since before a new zoning ordinance was enacted, it may continue as a non-conforming use, essentially being grandfathered, in as long as the use remains unchanged. Conversely, a variance allows a landowner to deviate from current zoning requirements due to specific hardship, while a conditional use permit grants permission for a specific use that is generally beneficial to the community but requires oversight. These mechanisms ensure that urban development remains orderly and safe, preventing incompatible uses from negatively impacting neighborhood character or safety. Government authority also extends to the power of eminent domain, which allows the state to acquire private property for public use, provided the owner is given just compensation. This process of taking property is officially called condemnation, and the government must prove that the land is necessary for a public purpose, such as a highway, utility line, or school. If a property owner feels that government action has effectively ruined the utility, value, or habitability of their land without a formal condemnation proceeding, they may initiate an action for inverse condemnation to recover compensation. In scenarios where a landowner dies without a valid will and leaves no heirs, the state may exercise its right of escheat to take ownership of the property. Texas statutes are very specific about this process, ensuring that the property does not remain ownerless or abandoned indefinitely. Understanding the distinction between police power, which regulates the use of land, and taxation, which generates revenue for the state, is critical for differentiating government actions. Private controls function quite differently from public regulations, primarily manifesting as deed restrictions, better known as covenants, conditions, and restrictions, or CC and RS. These are private agreements that run with the land, meaning they remain in effect even after the property changes hands, and they are typically enforced by homeowners associations. In Texas, the authority of these associations is strictly governed by the Texas Property Code, which mandates transparency, notice requirements, and specific procedures for imposing fines or placing liens for unpaid assessments. Unlike zoning, which is enforced by local government, CC and RS are enforced through lawsuits between private parties, often leading to court-ordered injunctions to stop a violation. It is vital to recognize that if a rule in a private deed restriction conflicts with a local zoning ordinance, generally the stricter of the two will prevail. Buyers must be thoroughly informed about these restrictions before closing, as they significantly limit how a homeowner may alter their property, from paint colors to architectural modifications. Beyond local and state regulations, large-scale developments that span state lines often fall under the jurisdiction of the Interstate Land Sales Full Disclosure Act. This federal law is designed to prevent fraudulent practices in the sale or lease of unimproved land by requiring developers of a certain size to provide a detailed property report to prospective buyers before they sign a purchase contract. The intent is to ensure full transparency regarding the features, development status, and potential risks of a land, protecting consumers who might be purchasing property sight unseen. For Texas licensee, it is important to understand that while local rules dominate most transactions, these federal disclosure requirements act as an important safety net for buyers involved in major modern subdivisions. By keeping these layers of regulation in mind, from the municipal zoning board to federal disclosure requirements, you can help your clients navigate the complex landscape of property rights with confidence and precision. I will see you in our next session. Welcome to the chapter on environmental hazards and how they influence property transactions in the state of Texas. We will systematically cover the legal frameworks governing environmental liability to ensure you are fully prepared for your certification. Environmental concerns are not merely technical or scientific matters in real estate. They are fundamental legal and financial considerations that can void a contract or impose lifelong liabilities. When we talk about the Comprehensive Environmental Response, Compensation, and Liability Act, or CERCLA, we are dealing with federal legislation that establishes broad responsibility for hazardous waste cleanup. Under this act, current owners can be held liable for remediation costs even if they did not cause the contamination themselves. This is why the innocent landowner defense becomes critical, as it provides a mechanism for those who performed rigorous due diligence to avoid punitive penalties. You must understand that simply buying a property does not shield a client from existing historical environmental issues. Mastering these concepts is essential because the financial repercussions of environmental mismanagement can be ruinous for your future clients. One of the most persistent issues you will face in residential real estate is the presence of lead-based paint in structures built before 1978. Federal law mandates that sellers provide specific disclosures to buyers regarding the known presence of such materials, and you are obligated to facilitate the delivery of the federally approved pamphlet. While this applies to homes built before that cutoff, it does not mean every old house is dangerous, but the law requires you to treat the risk as present until proven otherwise. Asbestos and radon represent other invisible hazards that demand professional inspection whenever they are suspected within a building structure. Mold has become a particularly sensitive topic in the humid climate of our state, and while regulations are evolving, disclosure of known moisture or structural issues remains mandatory. Effectively communicating these risks allows your clients to make informed decisions without unnecessary fear, while keeping you compliant with your agency obligations. Understanding administrative oversight is the next logical step in your educational journey. The Texas Commission on Environmental Quality, often referred to as the TCEQ, serves as the primary regulatory body overseeing industrial and residential environmental standards across our state. When commercial transactions are involved, you will encounter the necessity for Phase 1 and Phase 2 environmental site assessments to identify potential contamination. A Phase 1 assessment is a high-level review of the property history, while a Phase 2 involves actual physical testing of soil and water samples. These assessments are not just suggestions. They are standard operating procedures that mitigate risk for buyers, lenders, and investors alike. You need to understand that the Army Corps of Engineers may also interject in projects involving wetlands, as their jurisdiction over protected waterways is strictly enforced. Improper development on protected land can result in immediate cease and desist orders for your clients. Finally, we must address the practical reality of underground storage tanks that were once common on agricultural or industrial use properties. These tanks often leach hazardous petroleum products into the groundwater, creating long-term contamination issues that are incredibly costly to remediate. As a licensee, your role is to advise your clients to include inspection contingencies in their contracts to ensure these risks are identified before the deal closes. Sellers are required by law to disclose any known environmental hazards, but because many sellers might be unaware of hidden underground issues, the burden of inspection rightly shifts to the purchaser. Providing guidance on these matters is one of the ways you define your professional value to the client. Keep these regulatory thresholds in mind as you assess the viability of any property in the Texas market, as failure to disclose these items is a sure path to litigation. I look forward to discussing how these regulations dictate the process of your next real estate transaction in our upcoming session. Welcome to this chapter on the taxation of Texas real estate, where we will demystify the mechanics of property levies and taxpayer rights. This module provides the specialized knowledge required to navigate state-specific tax laws and ensures you are fully prepared to pass your TREC exam with confidence. In Texas, real estate taxation is primarily governed by the principle of ad valorem, which translates to a tax based on the value of the property rather than a fixed fee. The appraisal process begins with the County Appraisal District, or CAD, which is responsible for determining the market value of every taxable property within its jurisdiction for the official tax roll. This assessment creates the foundation upon which local taxing units, such as school districts, cities, and counties, apply their specific tax rates to generate revenue. Because this value directly dictates the financial burden on the property owner, is a point of significant regulatory precision and frequent dispute. As a practitioner, you must understand that the CAD does not set the tax rate itself, as that remains the prerogative of the elected officials within those various local taxing entities. Knowing how these market values are derived is essential for advising clients who may feel their tax burden is disproportionate to their actual property value. The Texas property tax system operates on a rigid calendar that you must commit to memory for the exam. On January 1st, a tax lien automatically attaches to all taxable real property to secure the payment of taxes for that year. Tax bills are typically mailed to property owners around October 1st, which marks the start of the collection cycle. Payments for these taxes are considered timely if paid by January 31st of the following year, after which they are officially classified as delinquent. Once delinquency occurs, penalties and interest begin to accrue on the outstanding balance, creating a significant financial incentive for timely settlement. Understanding this timeline is crucial because a failure to manage these dates can lead to a tax foreclosure, where the state enforces its lien to recover unpaid funds. Should a property be sold at a tax foreclosure sale, the law provides for a right of redemption, allowing the former owner a specific window to reclaim their interest. For a designated homestead or land that qualifies for agricultural use, the statutory redemption period is 2 years from the date the purchaser's deed is filed for record. In contrast, for non-homestead properties, that period is significantly shorter, lasting only 6 months from the date the deed is filed. During this time frame, the original owner must essentially pay the purchase price of the tax sale, along with recording fees, taxes, and other specified costs, to regain title to the property. This right serves as a vital safeguard for Texas homeowners and illustrates the state's legislative preference for protecting residential stability. A distinctive aspect of Texas tax law involves the special valuation known as agricultural appraisal, often referred to as 1D1 designation. This provision allows land used for farming, ranching, or timber production to be taxed based on its productive capacity rather than its market value, which is usually much higher due to development pressure. While this provides a substantial tax benefit for landowners, it comes with a strict condition known as a rollback tax. If the land stops being used for agricultural purposes, a penalty is imposed that effectively recovers the tax savings realized over the previous 3 to 5 years. This ensures that the tax incentive is reserved for legitimate rural productivity rather than merely serving as a way to hold speculative land at a lower cost until a future sale. Beyond property-specific designations, individual exemptions play a critical role in calculating the final tax liability for homeowners. The state provides mandatory and optional exemptions for specific segments of the population, including those over the age of 65, individuals with disabilities, and qualified veterans. These exemptions subtract a set amount from the appraised value of the home before the local tax rate is multiplied, directly reducing the total dollars owed by the resident. Managing these exemptions is a common advisory task, as homeowners must apply for them through their local CAD to realize the savings. Furthermore, if a taxpayer decides that their market value is incorrectly determined, they have the legal right to participate in an administrative protest process. This involves presenting evidence to the Appraisal Review Board, where an independent panel listens to both the CAD and the taxpayer to reach an equitable valuation. See you in our next session. Welcome back. Today we begin our deep dive into the legal framework governing how agency relationships are formed, maintained, and ultimately extinguished in the Texas real estate market. This chapter provides the bedrock for understanding your professional obligations as a license holder in our state. An agency relationship is fundamentally a fiduciary one, established when a person, known as the principal, authorizes a broker to act on their behalf. The creation of this bond often happens through an express agreement, which can be written or, in some limited contexts, oral, clearly stating the terms of the relationship. We also see the rise of implied agency, where the actions and conduct of the parties create a relationship even without a formal written contract. Furthermore, ratification occurs when a principal approves or accepts the benefit of an agent's unauthorized actions after the fact, effectively validating the agency relationship retroactively. It serves your interests to grasp these distinctions, as they define your legal standing and your liability from the moment you interact with a potential client. By mastering these foundational concepts, you ensure that every engagement you initiate is compliant with Texas law and your fiduciary duties. When we characterize agencies by their scope, we break them down into universal, general, and special categories. A universal agent has the authority to represent the principal in all matters, which is an extremely rare arrangement in real estate, typically established through a broad power of attorney. General agency is more common in professional settings, such as a property manager operating under a management agreement, where the agent has broad authority to conduct a series of transactions for a specific purpose. Conversely, the vast majority of real estate transactions are based on special agency, where a broker is hired for a single, specific task, such as selling a singular property. The listing agreement serves as a classic example of an employment contract for special agency, strictly limiting your authority to the scope of that specific listing. Understanding these tiers of power is essential for maintaining integrity in your practice and avoiding the pitfalls of overstepping your legal authorization. A crucial distinction exists between how you treat a client versus a customer, which often hinges on the duties you owe to each party under Texas law. A client is the principal to whom you owe the full spectrum of fiduciary duties, including loyalty, obedience, and full disclosure. A customer, on the other hand, is a party to the transaction with whom you do not have an agency relationship, yet you are still bound by the law to treat them with honesty and fairness. Navigating this fine line is a constant requirement for professional agents, especially during the early stages of contact. This dynamic is directly impacted by the requirement of identifying the substantive dialogue, which occurs when a substantive communication triggers the legal obligation to provide the information about brokerage services form to the prospective party. Failing to identify this moment is a clear path to regulatory friction, so you must remain vigilant in identifying when a conversation shifts from general inquiry to professional consultation. Termination of these relationships can occur through several legal avenues, and recognizing these triggers is just as vital as knowing how to form the contract. The most natural end to an agency is the completion of the purpose for which the agent was hired, such as the successful closing of a sale. Expiration of the term specified in the agreement or mutual agreement between the parties can also bring the relationship to a close without further obligations. Because agency is a personal relationship between a broker and a client, the death or incapacity of the broker effectively terminates the contract, as the agency is linked to the broker's individual professional authority. Similarly, the physical destruction of the property during the contract term renders the object of the agency non-existent. A unique scenario, known as agency coupled with an interest, occurs when the agent possesses a financial stake in the property itself, making the agency irrevocable by the principal. See you in the next session. Welcome back to our exploration of agency relationships within the Texas real estate market. In this session, we will unpack the fiduciary duties every agent owes to their principal using the industry standard framework. The foundation of the agency relationship is rooted in the mnemonic Old CR, which summarizes the core obligations of obedience, loyalty, disclosure, confidentiality, accounting, and reasonable care. Obedience requires that an agent follow all lawful instructions provided by the client, but it stops abruptly if those instructions are illegal or unethical. Loyalty demands that the agent places the principal's interests above all others, including the agent's own financial gain or convenience. This is the cornerstone of professional representation. Disclosure mandates that you must share all material facts with the client, ensuring they have the full picture to make informed decisions. Confidentiality is arguably the most enduring duty, as it persists indefinitely even after the agency relationship has formally terminated. While you must disclose material facts, you must never reveal sensitive details like a client's motivation for selling or the minimum price they would be willing to accept. Accounting is the strict management of any money or property held on behalf of the client. Finally, reasonable care and diligence require the agent to apply their professional expertise to tasks such as property valuation, contract drafting, and general transactional guidance. Understanding the distinction between disclosure and confidentiality is essential for managing your professional practice without accidentally violating your duties. Disclosure of material facts applies to everything that would reasonably affect a buyer's decision to purchase, such as structural issues, non-functioning systems, or title concerns. However, you must simultaneously protect the client's private information regarding their personal financial limits or their underlying urgency to close the deal. If a seller tells you they're forced to move due to a job relocation, that specific information is confidential and should not be shared with a potential buyer to leverage a higher price. In contrast, property defects are never confidential under Texas law and must be disclosed to ensure transparency and compliance. A failure to disclose a known material defect that affects the property's value or safety is a significant legal risk. Balancing these two requirements is where the true skill of the real estate professional is tested. You must constantly weigh the legal requirement to be open about the property against the contractual duty to keep your client's private leverage point secure. When an agent fails to uphold these fiduciary duties, the real-world consequences are severe and multifaceted. Breaching these obligations can lead to civil lawsuits initiated by clients who suffered financial harm due to the agent's negligence or self-dealing. Beyond private litigation, the Texas Real Estate Commission has the statutory authority to investigate and impose disciplinary actions against your license. These sanctions range from administrative fines to the suspension or even total revocation of your professional credentials. Furthermore, a court may order the forfeiture of any earned commission if the agent is found to have breached their fiduciary duty during the transaction. This highlights why strict adherence to these standards is not just a moral imperative, but a fundamental method for protecting your own career stability. You must recognize that the ethical path is invariably the safest route to long-term professional success in Texas. By documenting your actions and staying within the bounds of these duties, you insulate yourself from professional liability and reputational damage. Your duty to conduct a visual inspection is a specific component of reasonable care that often causes confusion for new licensees. Under Texas law, a listing agent is generally expected to perform a diligent visual inspection of the property to identify observable red flags. These are not hidden, technical defects that require an inspector's tools, but rather signs that a reasonable person would notice during a walkthrough. Examples include water stains on a ceiling, cracks in the foundation that are clearly visible, or evidence of significant pet damage. When you stumble upon these issues, your duty of disclosure overrides any desire to shield the seller. You must disclose these findings to all parties involved in the transaction to prevent future litigation based on deception or non-disclosure. Failing to notice or mention these obvious indicators of deterioration effectively violates the duty of reasonable care you owe to your client. It is your job to ensure that the client is not blindsided by issues that should have been documented at the start of the listing period. There is a fundamental contrast between the duties you owe to your principal and the duties you owe to a third-party customer in a real estate transaction. When working with a client, you are held to the high standard of fiduciary duty that includes loyalty and total confidentiality. However, when interacting with a customer who is not your principal, those fiduciary obligations do not apply. Instead, you owe a customer the duties of honesty and fair dealing, alongside the mandatory disclosure of all known material facts. You do not advocate for the customer, nor do you keep their personal motivations private, because they are not the ones who hired you to act as their agent. It is entirely possible to be both honest and fair to a customer while simultaneously fighting tooth and nail to secure the absolute best outcome for your client. Understanding this boundary ensures you do not inadvertently create an unintended agency relationship with a customer. Managing this duality is critical to maintaining a clear distinction between who you represent and who you are simply assisting in a professional manner. See you in the next session. Welcome to our discussion on intermediary practice in Texas, a topic that replaces the outdated concept of dual agency with strict, clearly defined legal protocols. This chapter will provide you with the essential framework to navigate complex brokerage scenarios, ensuring you remain compliant with TREC regulations while effectively serving multiple clients. In 1996, Texas moved away from the concept of dual agency, which inherently created an insurmountable conflict of interest where a broker attempted to represent both the buyer and the seller simultaneously. The legislature introduced the intermediary mandate to provide a structured, legal pathway for a single brokerage firm to facilitate a transaction involving its own clients. This legal transformation acknowledges that because a broker has a fiduciary obligation to all clients under their license, specific procedures must be followed to avoid a breach of duty. The primary requirement for practicing as an intermediary is the necessity of written consent from both the buyer and the seller. In current professional practice, this consent is typically secured at the beginning of the relationship through listing agreements and buyer representation agreements. Without this prior, written, informed consent, a broker cannot legally act as an intermediary, effectively barring them from the transaction if a conflict of interest arises. By ensuring this paperwork is correct from the start, agents solidify their legal protection and demonstrate their adherence to the Texas Real Estate License Act. When a broker acts as an intermediary, they must distinguish between two primary operational modes: intermediary with appointments and intermediary without appointments. Intermediary with appointments occurs when the broker assigns different sales agents from the same brokerage firm to represent the buyer and the seller respectively. In this setup, the appointed agents are permitted to provide advice, opinions, and negotiate on behalf of their respective clients, much like they would in a standard agency relationship. The broker, however, must remain neutral, overseeing the process without favoring one party or providing specific incentives to either side. Conversely, intermediary without appointments occurs when a single agent or broker assists both the buyer and the seller in a transaction. In this specific scenario, the broker is strictly prohibited from offering opinions or advice to either party, effectively acting as a neutral facilitator of the deal. This is a subtle but critical distinction that often appears on the state exam, requiring you to understand the limitations of counsel depending on how the appointment is managed. The role of the broker versus the sales agent is a fundamental component of these legal requirements, as the broker is ultimately held responsible for the intermediary process. When a broker acts as the intermediary, the individual sales agents involved are properly referred to as appointees if the broker chooses to make appointments. It is vital to recognize that the intermediary is the broker, not the individual sales agent, even if the agent is the one performing the daily functions of the transaction. The broker acts as an impartial bridge between the sides, but must not exert influence over the negotiations unless fully authorized by the appointments. Because the broker carries the license, they're the one legally liable if the intermediary protocol is not followed with precision. Understanding this hierarchical relationship helps clarify why documentation must be meticulous, as the broker needs a clear audit trail to demonstrate that they perform their duties within the legal bounds established by the state. One of the most consequential rules in intermediary practice involves the strict prohibition of disclosing confidential information without prior, explicit written authorization from the party. Even in the heat of a negotiation, a broker or an appointee cannot reveal that the seller might accept a price lower than the asking price, or that the buyer is willing to pay more than the offered amount. This also extends to sensitive information like a party's motivation for buying or selling, their relocation timelines, or their financial situation. If you're acting as an intermediary without appointments, failing to maintain this strict silence on price and terms is a direct violation of your fiduciary duties. Even when acting with appointments, your capacity to provide advice must not cross the line into unauthorized leaks of confidential material. Maintaining these boundaries protects the integrity of the transaction and ensures you stay compliant with the core tenets of the Texas Real Estate License Act regarding agency representation. You must also consider the requirement to provide a clear statement regarding how the broker will receive compensation during an intermediary transaction. Since the broker is acting in a balanced role representing both sides, the commission structure must be transparently disclosed to both the buyer and the seller. This ensures that there are no questions about where the broker's loyalty lies or if they are receiving remuneration that could be seen as an undisclosed inducement. Most standard TREC-approved forms contain sections that address this compensation, and it is your duty to ensure these sections are populated correctly before securing signatures. Failing to clearly state the commission agreement not only creates confusion for the parties involved, but also invites regulatory scrutiny that could jeopardize your license. Professionalism in real estate is fundamentally rooted in this level of transparent communication, especially when navigating the intricacies of multi-party agency representation. I will see you in the next lecture. Welcome to our deep dive into the organizational structure and ethical landscape of Texas real estate brokerage. In this chapter, we will examine the professional standards and legal frameworks that define broker responsibilities and agent conduct. The foundation of any brokerage relies on the precise classification of its sales agents, primarily through the lens of the Internal Revenue Code. In Texas, the vast majority of sponsored sales agents operate under an independent contractor agreement rather than as W-2 employees. This distinction is critical because it dictates how taxes are withheld, benefits are distributed, and how much control a broker exerts over the daily activities of their team members. While a broker cannot force an independent contractor to adhere to a strict hourly schedule, they remain legally obligated to provide adequate oversight, training, and guidance to ensure compliance with the Texas Real Estate License Act. Failing to supervise can lead to significant legal exposure for the broker, including vicarious liability for the agent's errors or omissions during a transaction. We must also address the specific rules regarding team branding, which exist to prevent public confusion regarding who actually holds the legal license. TREC regulations mandate that when a team operates under its own name, that name must be clearly linked to the broker's registered identity. Any advertising that omits the sponsoring broker's name or suggests that a team is a separately licensed entity is a direct violation of commission rules. The public has an inherent right to know that their contractual relationship resides with a licensed broker, not merely the marketing team or individual sales associates. Maintaining clear, transparent signage and digital media presence is not just a regulatory hurdle, but a fundamental aspect of professional business ethics in our industry. Ethics in real estate often centers on financial interactions, specifically regarding commission splits, referrals, and client rebates. Ethical dilemmas frequently arise when an agent is tempted to prioritize a higher commission split over the client's best interest, or when referral fees are exchanged without proper disclosure to all parties involved. Under Texas law, any compensation received for a referral must be clearly documented, and in many cases, disclosed to the principal to ensure there is no hidden conflict of interest. Furthermore, while offering a portion of a commission to a client is generally legal if handled correctly, it must be done with full transparency to satisfy fiduciary obligations. These ethical boundaries exist to protect the integrity of the market and the reputation of every licensed professional involved in a trade. The Sherman Antitrust Act represents a serious legal frontier that every broker must navigate to avoid federal enforcement actions. We must categorize illegal behaviors such as price fixing, where competing brokers conspire to establish standard commission rates, as fundamentally forbidden under federal and state law. Similarly, group boycotting, the act of choosing to exclude a competitor from business dealings, and market allocation, which involves dividing territories to eliminate competition, are strictly prohibited. These laws exist to foster a competitive marketplace where consumers are not penalized by artificial barriers that restrict their choices or force them into inflated pricing structures. As a license holder, you must ensure that your business interactions remain focused on independent competition rather than restrictive agreements with peers. Finally, the Deceptive Trade Practices Act, or DTPA, serves as a primary consumer protection statute that real estate professionals must respect at all times. A claim under this act does not require proof of intent. Rather, if a licensee provides false, misleading, or deceptive information that leads to consumer reliance and subsequent damages, they can be held liable. The act allows for the recovery of economic damages and, in certain cases of intentional behavior, mental anguish, potentially escalating to treble damages. Statutory defenses exist, such as the lien on the provider of written information or the timely offer of a settlement as defined by the statute, but relying on these is never a substitute for honest practice. Practitioners should always strive for complete disclosure and accuracy to avoid the severe consequences of modern consumer protection litigation. I will see you in the next lecture. Welcome to this chapter on disclosures in agency relationships. We will navigate the critical requirements for transparency and ethical conduct that protect both you and your clients in a Texas real estate transaction. In the state of Texas, the information about brokerage services form, commonly known as the IABS, serves as a foundational piece of communication between a prospective client and a license holder. It is important to distinguish this informational document from the actual verbal or written disclosure of agency representation. The IBS explains how agency works and the minimum duties a broker owes to a party, but does not create an agency relationship by itself. You must provide this information at the time of your first substantive dialogue with a party concerning a specific real property. If you fail to provide this notice, you risk not just disciplinary action from the Texas Real Estate Commission, but also the erosion of the trust required to effectively serve your clients. Understand that substantive dialogue involves more than just pleasantries or information about property features. It reaches into the specifics of a party's goals or financial situation. Think of the IBS as the mandatory baseline of professional transparency that every licensee must establish before meaningful business begins. Beyond the IBS, you are strictly required to disclose your actual agency status to other parties or their agents upon your first contact with them. Suppose you're calling a listing agent to inquire about a property. You must immediately state whether you represent the buyer or if you're acting as a subagency. Subagency is a concept that often causes confusion, but it essentially means that a license holder is representing a seller through the listing broker, yet is working with a buyer who has no form of representation. In this scenario, the subagent owes their primary fiduciary loyalty to the seller, not the buyer they are showing. Navigating these relationships requires a clear understanding of the chain of authority and to whom your duties reside. Transparency at the very first touchpoint minimizes legal exposure and ensures that all parties understand the playing field. If you cannot clarify your role, you risk inadvertently creating an implied agency relationship that could lead to claims of breach of fiduciary duty. Texas law strictly prohibits undisclosed dual agency, an arrangement where a broker represents both the buyer and the seller without the informed, written consent of both parties. While the practice of intermediary exists to allow brokers to facilitate transactions between their own clients, it requires rigorous disclosure and specific procedural adherence. Attempting to balance the interests of both sides without the formal intermediary process creates an untenable conflict of interest that is both unethical and illegal in our jurisdiction. Licensees must be vigilant about any situation that could be construed as representing both sides covertly, as this is a frequent source of litigation and commission complaints. You must ensure that if you find yourself in a position where both parties are your clients, you follow the required steps to designate the relationship as intermediary. Failure to do so exposes you to significant liability, as you would be providing services to one party that potentially disadvantage your fiduciary responsibility to the other. Another vital aspect of your professional conduct involves the seller's disclosure of property condition. While this is primarily the seller's responsibility to complete, the licensee serves as a critical guardian of this process to ensure accuracy and completeness. You have an affirmative duty to make sure your seller understands that they must disclose material facts concerning the physical condition of the property. If you become aware of a mismatch between the property's actual state and what is documented on the form, you must insist that the seller updates the disclosure or face potential allegations of misrepresentation. You should never advise a seller to omit negative information, as doing so puts your license and your client's financial future in jeopardy. Remember that your role is to facilitate honest disclosure, not to shield the seller from the consequences of accurate reporting. By maintaining this standard, you contribute to a transparent market where buyers can make informed decisions based on reality rather than omission. Finally, you must be hyper-aware of the mandate to disclose self-interest whenever you have a personal stake in a transaction. If you're buying a home for yourself, selling your own property, or represent a family member, you are required to provide written notice of this interest to all other parties before entering into any contract. This disclosure must be clear and direct, leaving no room for a counterparty to claim they were unaware of your personal affiliation. This rule exists to prevent any perception of self-dealing or the unfair use of your professional knowledge to the detriment of an unrepresented party. Failing to disclose that you are a broker or that you have a familial connection to a client is a significant violation of the canons of professional ethics. Transparency here does not just protect your license. It upholds the integrity of the real estate profession, which is inherently predicated on the trust that you are placing your client's interests above your own. I will see you in the next lecture. Welcome to our exploration of client and customer relations within the Texas real estate landscape. In this session, we will examine how agency law shifts from abstract theory to the practical daily duties you owe to both clients and customers. When you represent a party, you are operating under a fiduciary framework that requires undivided loyalty, but your responsibilities don't disappear when you encounter a customer. A client is someone you represent through a formal written agreement, such as a buyer representation agreement or a listing agreement, while a customer is a party to the transaction for whom you provide services but lack a formal agency relationship. You must always maintain professional boundaries, as the temptation to offer advice to a customer can easily blur the lines into unauthorized practice of law or unintended dual representation. While you owe fiduciary duties to your client, the law dictates that you must still treat all customers with honesty and fair dealing. This means you have an affirmative obligation to disclose all known material facts regarding the physical condition of a property to any party, regardless of your relationship with them. Failing to disclose these facts accurately could lead to significant legal liability and ethics complaints under TREC guidelines. Managing expectations from day one is the most effective way to protect your license and your reputation. In the context of for sale by owner or FSBO properties, your role as an agent requires a nuanced approach to avoid inadvertently creating a false sense of security for the seller. When representing a buyer in such a transaction, you must ensure that you secure an unrepresented seller compensation agreement if you expect to be paid by the seller. Without this document, your claim to commission becomes incredibly difficult to prove if a dispute arises later in the closing process. You cannot assume that an owner understands your role, so you must explicitly clarify that you represent the buyer's interests and that the owner remains responsible for their own legal and financial decisions. This proactive communication prevents the owner from believing you are acting as their agent, which is a common pitfall that leads to legal confusion. If you are operating under a limited service listing, you must pay strict attention to the broker's minimum service requirements as outlined in the Texas Real Estate License Act. These requirements ensure that even when a broker creates a bare-bones contract, certain core duties remain non-negotiable for the protection of all consumers in the marketplace. Commission disputes often boil down to the concept of the procuring cause of a sale, which is a principle grounded in your ability to demonstrate an unbroken chain of events that led to the transaction. If you find yourself in a dispute over whether you are entitled to a portion of the commission, TREC and local associations will look for clear evidence that your actions were the primary catalyst for the deal reaching completion. Simply showing a property is rarely sufficient if another agent performed the heavy lifting of negotiations or contract finalization. You must document your communications and maintain a detailed record of your efforts throughout the relationship to prove your role as the effective cause. This is exactly why maintaining an organized file for every client interaction is not just administrative busywork, but a vital safeguard for your professional revenue. By understanding these nuances, you demonstrate that you are not merely a facilitator, but a highly competent professional who respects the legal structures of the Texas real estate market. Maintaining clarity in your duties ensures that you are providing high-quality service while minimizing risk in every single transaction you handle. See you in the next session. Welcome back. Today we begin our deep dive into the legal bedrock of every real estate transaction, where we will methodically examine the essential elements that transform a simple agreement into a legally binding contract. Mastering these principles is non-negotiable for anyone serious about passing the Texas exam and protecting their future clients. At the heart of contract theory lies the necessity of mutual assent, commonly understood as offer and acceptance. For a contract to exist, one party must extend a clear offer, and the other must accept the terms exactly as presented without modification, which acts as a mirror image rule. Beyond simple agreement, a valid contract requires consideration, which is essentially the value exchange between parties, such as monetary payment or a promise to perform specific action. All parties involved must also be legally competent, meaning they must be of sound mind and meet the legal age requirement. Otherwise, the agreement might be challenged. Furthermore, the goal of the contract must be a lawful objective, as a court will never enforce an agreement to perform an illegal act. Finally, the Texas Statute of Frauds mandates that any contract involving the sale of real estate must be in writing to be enforceable in a court of law. When we categorize contracts by the nature of the promises involved, we distinguish between bilateral and unilateral agreements. A bilateral contract is one where both parties exchange mutual promises, such as a traditional purchase agreement where the seller promises to convey title and the buyer promises to pay the purchase price. Conversely, a unilateral contract involves a promise made by one party that the other party may accept through an action, such as an option contract or an open listing agreement where a broker is only paid if they successfully find a buyer. Understanding this distinction is vital because the expectations for performance differ significantly based on the structure of the agreement. While bilateral contracts bind both parties to specific duties immediately, unilateral contracts keep the obligation resting on one party until the specific condition is performed by the other. The legal status of a contract often shifts depending on how it was formed and whether it satisfies the required legal elements we just discussed. A valid contract meets all the necessary requirements of the law and is fully enforceable by either party. A void contract, however, is not a contract at all, often because it lacks one of the essential elements like a lawful objective, rendering it invalid from the very beginning. A voidable contract is slightly more complex, as it is valid on its face, but can be rejected by one of the parties, such as a contract entered into by a minor who lacks the legal capacity to give mature consent. Lastly, an unenforceable contract is one that may appear valid but cannot be forced through legal action, often because it fails the writing requirement under the statute of frauds. We also classify contracts based on their current stage of development, specifically focusing on whether the obligations are still pending or have been fully satisfied. An executory contract is one where the parties have signed the agreement and are in the process of fulfilling their respective duties, such as the period between signing the TREC 1 to 4 family contract and the final closing. Once all terms have been fully performed and the title has been transferred, the contract transitions into an executed status, signaling that the primary objectives have been completed. This distinction is important because it dictates the legal leverage each party holds during the life of the transaction. Tracking these stages helps you ensure that your clients remain in compliance with their contractual obligations until the very end. In the context of the TREC 1 to 4 family residential contract, the phrase time is of the essence serves as a critical directive that modifies the performance expectations of the parties. This clause stipulates that the deadlines set within the contract are strictly binding, meaning that failure to perform by the specified date constitutes a material breach of the agreement. A common practical application is the option period, where a buyer pays a fee for the right to terminate the contract for any reason within a specific time frame. If the buyer does not act or notify the seller before this window closes, they lose that specific contractual right. Treating these time constraints as absolute rather than flexible guidelines is essential for protecting your client's interests during transaction. When a party fails to fulfill their duties, we must analyze the available legal remedies that serve as a recourse for the aggrieved party. Specific performance is a legal remedy where a court orders the breaching party to actually fulfill their contractual obligations, which is common in real estate because every piece of land is considered unique. Alternatively, contracts often include a provision for liquidated damages, which in many Texas residential transactions is represented by the earnest money deposit. If the buyer defaults, the seller may choose to retain the earnest money as compensation for the breach, effectively capping the buyer's liability. The final option is to sue for actual damages, which involves seeking a court judgment for the specific financial losses sustained due to the breach, though this is often the most time-consuming and costly path to resolution. I will see you in the next lecture. Welcome back. In this lesson, we will examine the structure and application of TREC promulgated contract forms to ensure you can navigate the core paperwork of Texas real estate transactions with precision. The Texas Real Estate Commission acts as a regulatory checkpoint, dictating specific forms under the category of promulgated contracts. It is essential to distinguish between promulgated forms, which are mandatory for license holders to use in standard transactions, and approved forms, which are optional. Unauthorized practice of law remains a significant concern for licensees. Therefore, you are strictly prohibited from drafting complex legal provisions that extend beyond the standard language provided by the Commission. When we look at the 1 to 4 family residential contract, we are looking at the primary vehicle for most resale transactions. This document serves as the foundation for your contractual obligations and protects both the buyer and the seller through clearly defined language. Understanding the hierarchy of these forms ensures that you maintain compliance while fulfilling your fiduciary obligations to your client. You must strictly adhere to the fill-in-the-blank nature of these contracts, as adding extraneous language often creates unnecessary liability. Consistent use of these forms establishes a professional standard that protects the integrity of the contract and the interests of the parties involved. Paragraph 2 defines the property and the fixtures involved in the sale, which is often where disputes arise if the documentation is imprecise. You must articulate the legal description clearly and verify the inclusion of non-realty items that the seller intends to convey. Paragraph 3 focuses on the sales price, requiring a breakdown of the cash portion and the financing amount, which must reconcile perfectly with the third-party financing addendum. When we move to paragraph 5, the earnest money and option fee structure comes into play as the consideration for the contract and the unilateral right to terminate. It is critical to grasp that the option fee must be delivered within the time frame specified, or the buyer loses the unrestricted right to terminate for the option period. Paragraph 7 covers property condition and the seller's disclosure notice, which is a mandatory statutory requirement in most residential sales. Should the buyer require repairs, this section provides the mechanism to negotiate those terms before the transaction proceeds. Every elective section within these paragraphs must be completed accurately to avoid creating an ambiguous contract that could lead to litigation or commission disputes. Paragraph 11, titled Special Provisions, is essentially a high-risk zone for the average licensee. You are only permitted to insert factual business information or factual statements that are required by the transaction, not legal interpretations or complex contingencies. If you attempt to draft conditions that are essentially an exercise of legal expertise, you're stepping into the unauthorized practice of law, which can cost you your license. The Commission expects you to know when a situation requires an attorney rather than a real estate agent. Recognizing the limits of your role is a demonstration of professional competence rather than a limitation of your utility to the client. Keep the language in this paragraph strictly transactional and avoid legalistic jargon that attempts to rewrite contract terms. If a client insists on complex language, your advice must be to consult with qualified legal counsel. This distinction keeps the transaction focused on the transfer of real property and prevents the contract from becoming a liability for the broker. Beyond the standard 1-4 resale contract, you will encounter other forms such as the unimproved property contract, the new home construction contracts, the residential condominium contract, and the farm and ranch contract. Each of these is specifically tailored to unique asset classes, and using the wrong form is a violation of TREC rules. For example, the condominium contract necessitates specific disclosures regarding the association and management certificates that are absent from other contracts. Mastery of the effective date is the final piece of the puzzle. As all performance deadlines are calculated from the calendar day, the contract becomes fully executed and communicated. You must track these dates with absolute precision, as missing a deadline by even one day can result in a contract breach. Calculating days and time frames requires a standardized approach to avoid ambiguity between the parties. As you gain more experience, you will notice that the consistency of these forms significantly reduces the friction in real estate closings. See you in the next lecture. Welcome back. In this lecture, we will examine the distinction between addenda and amendments and how to properly utilize these forms within the Texas real estate framework. When navigating Texas real estate transactions, it is critical to distinguish between an addendum and an amendment. An addendum is an attachment to the primary contract that functions as an integral part of the agreement, usually added at the time the offer is originally drafted and executed. Its purpose is to provide additional terms or to clarify conditions that are not fully covered in the standardized, promulgated contract forms. Conversely, an amendment is used exclusively after a contract has already been fully executed by all parties. If the buyer and seller agree to change the purchase price, modify the closing date, or adjust repair agreements once the escrow period has begun, they must use the TREC amendment form. Confusing these two instruments can lead to unenforceable agreements or, at the very least, significant administrative headaches during the closing process. The third-party financing addendum is perhaps the most familiar form, as it acts as a safeguard for buyers relying on loans. This document specifies the type of financing sought by the buyer and serves as a contingency, potentially allowing the buyer to terminate if they cannot obtain credit approval within a predetermined time frame. It is a protective mechanism that ties the contract's validity to the buyer's ability to secure funding under specific terms. Similarly, the addendum for sale of other property by buyer is a powerful tool when a buyer must liquidate their current residence before they can afford to close on a new one. This form essentially buys the buyer time while keeping them legally tethered to the contract, though it does include specific provisions regarding the seller's right to continue marketing the property to other prospective buyers. In competitive markets, the backup addendum allows a buyer to position themselves as the secondary choice should the primary contract fall through. The primary contract must be officially terminated before a backup contract can elevate to the primary position. This requires careful coordination and transparent communication with the parties involved to avoid legal ambiguity. For distressed properties, the short sale addendum addresses the unique challenges where the seller's mortgage balance exceeds the market value of the home. This form acknowledges that the transaction is subject to the lender's approval, which adds layers of complexity and waiting periods that are absent from standard real estate transactions. Understanding these forms ensures that you maintain control over the transaction timeline, regardless of the unique financial circumstances presented. The non-realty items addendum is vital when the deal includes personal property, such as refrigerator units, specialized media equipment, or high-end furniture that the buyer wants to purchase alongside the real estate. Since the primary contract concerns only the real property, failure to explicitly list personal items in this addendum can lead to disputes at the final walkthrough. You must also be diligent regarding the lead-based paint addendum, which is a federal mandate rather than just a TREC preference. This disclosure is mandatory for any residential property constructed prior to 1978 and must be provided to the buyer before the contract is finalized. Failing to include this document doesn't just invite a breach of contract. It invites federal regulatory scrutiny, making it a non-negotiable step in your professional practice. Finally, we must consider the administrative life cycle of a transaction. specifically the notice of buyer's termination of contract and the release of earnest money forms. These are not merely paperwork. They're the formal mechanisms that clear the title and release the parties from their previous legal obligations. The notice of buyer's termination is the definitive way for a buyer to communicate they are exercising a contractual right to cancel, such as during the option period. Once that notice is served, the parties must then resolve the disposition of the earnest money deposited in escrow. Utilizing the generic release of earnest money form ensures there is a mutual, written understanding of who is entitled to those funds, thereby preventing lingering claims that could cloud the property's title for future buyers. I will see you in the next lecture. Welcome back. In this chapter, we will master the intricacies of financing addenda, title procedures, and the final steps of closing a real estate transaction. When we look at the integration of financing into the contract process, we're essentially looking at how a buyer bridges the gap between their liquid assets and the purchase price. In Texas, the third-party financing addendum is the tool that facilitates this bridge, clearly outlining whether the financing is conventional, FHA, or VA. Conventional loans usually carry fewer restrictions than government-backed ones, but FHA and VA loans have specific requirements regarding property condition and appraisal values that you must be aware of. If a property fails to appraise at or above the purchase price, the financing addendum provides the buyer a way to exit the contract or negotiate further, which is a critical protection. You must understand that these documents are not just suggestions. They define the legal obligations for securing the loan within a specified time frame. Failure to adhere to these timelines can result in the loss of earnest money. So precision is your best friend when filling out these forms. Ensuring your client understands the difference between the loan commitment and final approval is part of your professional duty as a licensee. Once the contract is active, the title company steps in as our neutral escrow agent, tasked with ensuring the integrity of the transaction. They examine the chain of title to identify any encumbrances, liens, or easements that might cloud the ownership transfer. The commitment for title insurance is effectively the promise that, if the transaction closes, the company will issue a policy protecting the buyer against defects in title. You should advise your clients to review this commitment with a fine-tooth comb because it highlights exactly what is covered and, more importantly, what is excluded from coverage. The title policy itself is a permanent safeguard for the buyer, ensuring that they truly own the bundle of rights associated with the property. It is your job to ensure the client understands that the title company holds the funds and documents in trust until all conditions are satisfied. Misunderstandings at this stage can lead to unnecessary delays, which is why transparent communication with the escrow officer is vital for every agent. The actual conclusion of the transaction involves the distinction between closing and funding, a nuance that often confuses clients. Closing is the moment when all documents are signed, and the legal transfer of the property title is recorded at the county courthouse. Funding, however, occurs when the lender actually releases the money to the title company for distribution to the seller and other service providers. Under the TREC Integrated Disclosure Rule, we use the Closing Disclosure, or CD, to provide clear, standardized information about the loan terms. This document replaces the old HUD-1 and must be delivered to the borrower at least 3 business days before the scheduled consummation. This window of time is strictly enforced to prevent last-minute surprises or predatory lending practices from going unnoticed by the buyer. As an agent, you should be adept at explaining the charges on the CD, ensuring your client feels confident in the financial breakdown, including the escrow setup and interest allocations. Prorations are another area where precision determines whether the transaction feels equitable for both parties involved. When dealing with taxes, interest, or homeowners association dues, you will frequently calculate these based on a 360-day year, assuming 30 days in every month, or occasionally a 365-day year. You must verify which method the contract specifies, as failing to use the correct calculation can result in incorrect credits or debits on the final settlement statement. These small adjustments ensure that the seller pays for the period they occupied the house and the buyer takes responsibility from the closing date forward. Attention to detail here is a hallmark of a competent professional who wants to avoid disputes long after the keys have been handed over. Always double-check your math, as a simple decimal point error can lead to an uncomfortable conversation during those final high-stakes moments. Finally, we must address the possession paragraph and the use of temporary residential leases. While standard practice dictates that possession occurs upon closing and funding, life rarely adheres to such perfect constraints. If a seller needs more time to move or a buyer needs to move in early, a temporary lease is required to protect the interests of all parties. These leases clarify liability, dictate per diem rates for occupancy, and define the condition of the property during that short-term window. It is hazardous to allow a client to take possession without a formal lease, as it can turn into a legal quagmire if the deal falls through or property damage occurs. By using the standard TREC promulgated forms for these temporary arrangements, you maintain a clear audit trail and protect your client from unforeseen risks. Always ensure these addenda are fully executed before anyone starts moving boxes into the property. See you in the next lecture. Welcome to our exploration of property management and leasing, where we will master the essential legal frameworks governing landlord-tenant relationships in Texas. In this chapter, we will examine the specific leasehold estates, mandatory compliance rules, and the fiduciary responsibilities that define the property manager's role. To understand leasing in Texas, we must first categorize the 4 types of leasehold estates, which define the duration and nature of a tenant's right to occupy property. An estate, for years, perhaps counterintuitively, describes any lease with a specific beginning and ending date, such as a 6-month rental or a 5-year commercial contract. A periodic estate automatically renews at the end of each period, such as a month-to-month lease, typically requiring proper notice for termination. An estate at will exists when a tenant occupies property with the owner's consent, but without a fixed duration or rent payments, essentially continuing until either party chooses to terminate the arrangement. Finally, an estate at sufferance occurs when a tenant initially gained possession lawfully, but remains in the property after their legal right to do so has expired, effectively becoming a holdover tenant. These distinctions are critical because they dictate the termination procedures and rights available to both the property owner and the occupant during the life cycle of the tenancy. When looking at the specific documentation, we must acknowledge that while TREC does not provide a vast library of residential lease contracts, understanding the principles found in the standard forms used across the state is paramount for your licensure. A primary concern for any manager is the handling of the security deposit, which in Texas must be returned to the tenant within 30 days after the tenant vacates the premises and provides a forwarding address. Another unique aspect of Texas law is the requirement for rekeying residential rental properties, which must occur within 7 days after a new tenant occupies the unit. These mechanical and financial requirements protect the tenant and ensure the landlord maintains a habitable environment. Yet they also create strict compliance timelines that a manager cannot afford to miss. Fiduciary duties remain front and center here, as the property manager acts as the primary agent for the property owner, balancing the owner's investment goals with the legal necessity of fair treatment for all applicants. Professional property management necessitates a robust understanding of tenant screening and fair housing compliance, as illegal discrimination during the selection process is a primary source of legal liability. A manager's core function involves fulfilling the fiduciary duty to the owner, which includes performing routine maintenance to protect the asset's value and ensuring the property remains in compliance with all local codes. However, this duty never supersedes the requirements of federal and state fair housing laws, which strictly prohibit discrimination based on protected classes during the marketing, application, and leasing process. Problems can arise if a manager fails to provide a habitable environment, potentially leading to a claim of constructive eviction if the landlord effectively renders the property uninhabitable. In such a case, a tenant might argue their obligation to pay rent has ceased because the property is no longer functional, creating a significant legal burden for the owner. When a tenant stops paying rent or otherwise breaches the contract, the manager may need to initiate the forcible entry and detainer process, which is the formal legal procedure for eviction in Texas courts. It is important to note that while some tasks in property management may be performed by on-site staff, the person who negotiates leases or manages trust fund for others must generally hold an active real estate license. This requirement ensures that those responsible for significant financial transactions and legal declarations are held to the standards of the Texas Real Estate License Act. If you are operating as a property manager, you are effectively a broker for the landlord's interests, and your actions are imputed to the managing broker. This means that any failure to maintain proper escrow account records or any violation of the landlord's fiduciary obligations will reflect directly on your broker's license. Mastering these nuances of delegation, compliance, and legal procedure is essential not only for passing the state exam, but for mitigating the high-stakes risks inherent in managing real estate assets for third-party owners. I will see you in the next lecture. Welcome to our deep dive into the Texas Deceptive Trade Practices Consumer Protection Act, often referred to simply as the DTPA. The Texas Deceptive Trade Practices Consumer Protection Act serves as the primary tool for consumers to hold businesses accountable for misleading or fraudulent conduct. In the context of real estate, this statute empowers buyers or tenants to take legal action against license holders who engage in prohibited practices. To understand the Act, we must first define who constitutes a consumer under the law. A consumer is an individual, partnership, or corporation that seeks or acquires goods or services by purchase or lease. In real estate transactions, this is almost always the buyer or the lessee. The scope of the Act is limited to those engaged in trade and commerce, which encompasses the advertising, offering for sale, and the actual transfer of real property. By engaging in these activities, a real estate agent is directly subject to the provisions of the DTPA. A significant portion of the litigation surrounding this act centers on the so-called laundry list of prohibited practices. This list includes specific violations, such as representing that goods have sponsorship, characteristics, or benefits they do not actually possess. For instance, claiming a property is located in a highly sought-after school district when it factually belongs to a different one is a classic violation. Similarly, misrepresenting the geographic origin of goods or services or implying that a property involves rights or remedies that it does not have will trigger liability. License holders must be careful to distinguish between these concrete misrepresentations and mere puffing. Puffing refers to the exaggerated, subjective, and boastful statement that a reasonable person would not rely upon for factual accuracy. If you tell a client that a home is the most beautiful residence in Texas, you are puffing, but claiming the roof is brand new when it is 20 years old is an actionable misrepresentation. Many agents attempt to mitigate their risk by including an as-is clause in the purchase contract, yet this is not a complete shield against DTPA claims. While such a clause may effectively waive certain common law claims, it does not automatically bar a consumer from asserting a violation of the DTPA. Providing the buyer with a full, honest disclosure of all known material defects is the only professional way to handle the condition of a property. When relying on third-party documentation, such as a professional property inspector's report, an agent has a statutory defense under the DTPA. If you provide information obtained from an official report without knowing it was false or misleading, you are generally protected from liability. The key to maintaining this defense is ensuring you are acting as a conduit rather than an originator of the specific misinformation. The financial stakes in a DTPA lawsuit are substantial because the law provides for economic damages and potentially mental anguish damages. If the court finds that the license holder acted knowingly or intentionally, the consumer may be awarded treble damages, which is literally 3 times the amount of the actual economic loss. Knowing conduct means the agent had actual awareness of the falsity or deception, while intentional conduct implies a specific desire for the consumer to act in reliance on the falsehood. To minimize these risks, the best strategy is proactive and transparent communication. Always document your interactions, encourage independent inspections, and never attempt to interpret technical data beyond the scope of your professional expertise. By relying on experts and providing full transparency during the disclosure process, you effectively manage your exposure to these significant legal consequences. I will see you in the next lecture. Welcome back. In this final lecture, we move beyond the technical curriculum to discuss exam mechanics and synthesize the foundational concepts required to secure your Texas real estate license. Successfully navigating the Pearson VUE testing environment requires more than just raw knowledge of real estate principles. It demands a strategic intellectual framework. When you sit for the exam, you will be confronted with a bifurcation of topics: the national portion and the state-specific section. The national portion weighs heavily on general principles of agency, property ownership, and contract law, while the Texas portion tests your granular understanding of TREC rules, the statutory requirements of the Texas Real Estate License Act, and specific promulgated forms. You should approach the exam by mentally categorizing every question into these 2 buckets before you commit to an answer. High-value topics, such as agency relationships and contract formation, are the backbone of the exam, and precision here is non-negotiable. If you find yourself struggling with a specific question, utilize a disciplined process of elimination. By stripping away clearly incorrect options, you increase your statistical probability of success, even when the primary answer is not immediately obvious. Test anxiety often arises from the fear of the unknown, but the logistics of the exam day are standard and predictable. You must ensure you arrive at your scheduled Pearson VUE location with the exact forms of identification required by their protocols. Failing to provide the correct documentation will result in a denial of entry, regardless of your preparation. Inside the testing facility, your primary objective is to maintain a rhythmic pace that prevents you from lingering too long on any single item. If a question feels conceptually impenetrable, flag it and move on, banking your time for items where your certainty is higher. Remember that the exam is designed to test your baseline competency as a practitioner, not your ability to recall obscure trivia. Once you submit your final answers, the result is typically generated in real time. You will receive an immediate notification of your pass or fail status, which effectively concludes the state's assessment of your readiness to enter the profession. To synthesize our review, let us consolidate the mandatory figures and timelines that frequently appear as testing criteria. A property owner has a specific window of years to claim a homestead exemption after the property has been sold or the tax assessment has occurred, and knowing this timeline is essential for client advisory. Regarding security deposits, a landlord is statutorily obligated to return the deposit or provide an itemized list of deductions within a fixed number of days after the tenant surrenders the premises. Tax liens in Texas possess their own rigid hierarchy and expiration mechanics, which must be clearly distinguished from more general property encumbrances. Furthermore, as an active licensee, you must remain acutely aware of your continuing education requirements and the specific number of hours needed for license renewal during each term. These numbers are constant, objective, and represent the kind of rote information that separates candidates who pass on their first attempt from those who are forced into a retake. As you transition from this course to the actual examination, view your knowledge not as a static collection of facts, but as a system of professional safeguards. The Texas Real Estate License Act exists to protect the public, and your role as a licensee is to operate within the strict boundaries delineated by the Commission's authority. When you encounter complex questions regarding intermediary practice or deceptive trade practices, Always return to the core fiduciary duty you owe your client. If a scenario suggests a conflict of interest, the safest path is almost always the one that favors maximum disclosure and strict adherence to the TREC promulgated forms. By maintaining this focus on regulatory compliance and ethical consistency, you ensure that even difficult, nuanced questions can be solved by applying the fundamental principles we have discussed throughout our time together. Trust in the rigorous structure of the statutes, remain deliberate in your strategy, and keep your focus on the precise requirements defined by the state of Texas. See you in the next lecture.